monetized. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up.
And this area is a street that traverses north and south. North being this way, south being that way. West being here at the top, as I understand it. And this is the area here where these bodies were found. This is Nicole Brown Simpson's residence. It's the residence which she had purchased. You recall, with the funds that she'd gotten from the money that Mr. Simpson had given before he married, and there's some additional funds that he'd given her. She had moved there voluntarily. And you heard the approximate distance between the two. What's your homework? Mr. Douglas, why don't you put yours up? Now, before we go into the timeline, we'll talk more about this, and you'll hear more about this when we discuss so-called alibi testimony. One of the things that I expect the evidence to show in this case is that Mr. Simpson does, in fact, have an alibi for his whereabouts on that particular night during the critical time. You'll recall that the prosecutors in their opening statement talked about a period of time between 9:45 and about 11. So our evidence here this afternoon will track that same period of time, 9:45 p.m. till about 11 o'clock p.m. And you'll recall the testimony that you've heard so far, that Ms. Nicole Brown Simpson spoke to her mother and an individual at the Mezzaluna restaurant, certainly in the area of 9:42 or thereabouts, had 2 phone calls in that period of time. So it's reasonable to assume that she certainly was alive at that particular point in time. So that's probably a very good starting point. What you have on the board, and this number, Mr. Douglas, what's his number again?
213.
All right, this is 213. This is a view, a side-by-side view of each of these residences side by side. What we're going to do is we're going to start at 9:45, and in each instance for Rockingham and for Bundy, tell you what we expect the evidence to show of the various parties and where they were. Let's take the graphic on the board. What's that number, Mr. Harrison?
107.
Thank you. At 9:45, at the Rockingham residence, Mr. Simpson's, you'll see in this thing, we think the evidence is going to show that Cato Kalin is in his quarters, Mr. O.J. Simpson's in his quarters, and to the right here is Rosa Lopez, and you'll see this area. Let me just use this as an example. Hold it for him, Mr. Harrison. I think the evidence will show that the side of the house, Rosa Lopez lives right over in this part here, but there's this side of the house, a little walkway that goes right down the side of the house, back this way. That's where Detective Herman claims he found the glove in this very, very small area. It leads back out here somewhere. So 9:45 at the Rockingham residence, you see the parties who are there. Mr. Douglas has charted that on the chart here. You can see it in both places. Mr. Harris, the next one.
D109.
All right, at 9:45 or thereabouts at Bundy, you'll recall this is the residence right there on Bundy. And we know from, expect the testimony to be, that Mr. Cole Brown Simpson had a phone conversation with her mother and with somebody at the Mezzaluna restaurant about having the glasses which the party had left at Mezzaluna. We can expect she's still very much alive at that particular time. Mr. Harris?
D110.
We're taking this in 5-minute intervals, and obviously these intervals of this, because you're doing it within 5 minutes, it's not exact, but it's as close as we can approximate based upon the evidence as we now understand it. At 9:50, parties in their same relative positions, Rosa Lopez, Mr. Simpson, Mr. Cato Kalin still in the side his residence. 9:50,
111.
number 111, same situation with regard to Bundy.
D112.
9:55. Again, now keep in mind that the testimony will be that Rosa Lopez at about 8:15, between 8:15 and 8:30, has come out. She's seen this Bronco parked there. She's walked her dog somewhere back in this area over here that I'm indicating with the light, and she sees the Bronco kind of parked somewhat askew. And at 9:55, this is the relative positions that we think the evidence will show the parties at Rockingham at that time.
D113.
9:55, nothing else has changed at the Bundy scene at that point. Mr. Harris?
D114.
At 10 o'clock. This is in Rockingham, and at 10 o'clock, for your attention, I think you'll find there'll be testimony that the Bentley, of course, that Mr. Simpson and Mr. Cato Kalin had gone to get the McDonald's, the hamburgers in, parked in the yard there. That Cato Kalin is taking his food back to his room to eat. That they'd gone somewhere around 9 o'clock. They got back somewhere around 9:37 to 9:40, somewhere in that area. Bentley was parked. Mr. Simpson had eaten his hamburger. Rosa Lopez remains at the same place. We've drawn in, based upon what we expect the testimony to be, the car on the Ashford side here, the Cato Kalin's car. It's all in black there. And you see, of course, the Bronco. That's the 10 o'clock scene as we expect the evidence to show at Rockingham.
D115.
Now at Bundy at 10 o'clock, we expect there will be testimony that a man named Tom Lang, same name as the detective in this case, but not the detective, a witness, we think will testify that he's out, as so many people in this neighborhood do, walking his dog down here. There's a street down here called Dorothy Street. There's this dog, and he's out walking the dog, and that he makes a statement to the police, which he tells the police that he sees a lady who fits the description of Nicole Brown Simpson wearing something, some kind of a black dress. The detective who takes the statement down, the evidence will show, miswrites it and puts it like a white flowing dress. But he tells him black dress, I think, the evidence will show. But he sees from this location down here, he sees this lady whom he believes is Nicole Brown Simpson, either touching or in some way embracing someone at a car parked at this curb, right about in this area here. And he is south of their location, and he sees a gentleman at the car, and he sees Mr. Cole Brown Simpson. What he also sees, he sees a man he describes as a Hispanic gentleman standing on the sidewalk beyond where Mr. Cole Brown Simpson and this gentleman are, and he is standing with his fist clutched, as I'm indicating for the record, staring down at Mr. Lang. He thinks that this man may be angry with him because his dog is loose or whatever. So that's Mr. Lang, and that's 10 o'clock at that, and this is the residence here, that's 10 o'clock at the Bundy Street location. And if Mr. Lang, of course, is correct, and Nicole Brown Simpson is still alive, of course, at that point. At 10:05, at the Rockingham residence, Mr. Simpson has come outside the house. Mr. Simpson, I think the evidence will show at some point, made a telephone call somewhere between 10 and 10:05 to his then-girlfriend, Paula Barbieri, on a portable phone that he'd had in this Bronco. There was a phone call. He was unable to hook up with her, but he did, in fact, make this phone call. I think there'll be records of whatever that affects. So at 10:05, that's the situation there with Cato Kalin still being in his room and Rosa Lopez still being at her location.
D116.
10:05, we still have the same situation at the Bundy location. We have Tom Lang, still at his same approximate location as we described. After making the phone call at the Rockingham location, we now have Mr. Simpson back inside. Mr. Simpson very often will swing golf clubs, which he keeps all over the place, in Bentley, in the garage or whatever, I think the evidence will be, and that he sometimes will chip. For you, those of you who are golfers, he'll chip or swing his 4-wood or 3-wood, generally over in this direction over here, where there's some sand where the kids can play and that sort of thing. But during this period of time, Mr. Simpson, at some point, swings his golf clubs or whatever, and at some point, at this point and later, chips, so he's out in this yard area after having made the call.
So with D118, D119,
10:10, not much happening at the Bundy that we can tell.
D120,
All right, after Mr. Simpson has done that and been outside, make his phone call, I think then you'll find the relative positions of the parties. Simpson back inside the residence. The evidence will be he's going to Chicago. At some point he has to pack, get ready. Cato Kalin's in his room. Rosa Lopez still at her location at that point, although she's just about to leave.
C-121.
Same situation at 10:15 on the Bundy location.
C-122.
This location at about 10:15 to 10:20, Rosa Lopez then comes outside of her location to walk her dog again. And she comes out in this general area to the right here on Rockingham. We expect the testimony to be that Rosa Lopez sees the Bronco still parked the same configuration, same location, just like she had seen it between 8:15 and 8:30. She sees it between 10:15, 10:20, the same location. And we think she'll also testify she saw this same Bronco parked in the same manner, same location, same configuration the next morning after she had talked with Detective Furman. That's Rosa Lopez at 10:20, thereabouts, at Rockingham.
C-123.
At 10:20, contrary to what you've been told, I think, by the evidence by the prosecution that they can determine death by the plaintiff will of a dog, we have some live witnesses, Ellen Aronson and Dan Mandel. It's the two that I alluded to earlier who've been apparently on this date to Metzaluna, and they're walking home. They're walking down Bundy from north to south at about 10:20. They walk north to south. This location, as I've indicated here. Thank you, Mr. Harris.
C-124.
At the other location, at about 10:25, we expect that Rosa Lopez at the Rockingham is certainly going back inside the residence now, having walked the dog. Mr. Simpson inside the residence, Cato Kalin inside the residence, and we have now for the first time the limousine driver, Alan Park, who comes up. And it's interesting, if you, can you back that up for a minute, Mr. Harris? Interesting at the 10:25 location, and you'll recall because I read you the testimony of Alan Park at both the preliminary hearing and the grand jury, so that he didn't see or didn't look to see any other cars. Ms. Cato Kalin's car was there. He didn't look to see this Bronco was down there. And you will hear evidence, I'm sure, with regard to whether or not, what about the streets at that time of night, 10:25, 10:30 on a Sunday in Brentwood? What might you expect to hear? Were there lights on? What would be observable at that location? I believe, hopefully, we'll be able to go out to these scenes at night also. So we have Cato Kalin's car, Alan Park's limousine, and the relative positions of the other parties. We're going now back to Bundy.
C-125.
Now, by this time, according to what I expect the testimony to be, Ellen Aronson and Dan Mandel have continued walking south on Bundy, and now they are right in front of the residence there at Bundy. The importance of this, we think the evidence will show, that they walked there in this very short distance, right to their right. If the crimes had occurred, would be these bodies, with the gate open, with blood flowing down. Remember when I read this morning from Phillips's transcript, when he was talking to the coroner about the need to come out there. These bodies are right there. They can be seen from the sidewalk or from the street. So these people are in a rather unique position. I believe that their testimony will be they saw no bodies, they saw no gate open at that point. It was approximately 10:25 when they're walking at this particular location. So that they become, as with all witnesses, very important. They become particularly important when the prosecution tries to present a theory that these killings had occurred at 10:15.
E-126.
Back at 10:30, we have Rosa Lopez go back to her house. Everybody else in their same positions. Park is still out with the limousine. In fact, Park has at some point gotten outside the vehicle. If the testimony will be, and he's somewhere out here on the Ashford side of the residence.
E-127.
10:30, I think we now have Robert Heidstra, who is in this alley. I described for you before an alley that runs parallel to Bundy, and this will be measured for the distance between this alley and Bundy there. But he also is out walking his dog on this Sunday evening. He's walking in this direction, again apparently from north to south. And it's about 10:30 that he first appears.
E-128.
10:35, the situation is still pretty much the same at this point. The limousine driver is early. The roles of the various people appear approximately the same, 10:35.
E129,
10:35. Now you'll recall that Ellen Aronson and Dan Mandel have walked past this location at about 10:25. They don't see any bodies or gates or any blood. Now this man, Robert Heistra, is in this alleyway. I believe the testimony will be that at 10:35 or thereabouts, he hears some unusual things. He hears the sound, hey, hey, hey. He hears, I believe you'll hear, a gate playing or closing. There will be testimony there are gates back this way at the Nicole Brown Simpson residence, in addition to the one in the front. That he hears the sound of men arguing. I believe is what the testimony will be. So from this location, he can hear this. He hears this going on. He hears that to be at about 10:35 p.m. That's at the Bundy location. He's in the alleyway, and he's approximately parallel to the Bundy location, except he's in the alleyway off of Bundy. It's at 10:35.
E130,
We know that, according to the testimony of Mr. Park, at some point, about 10:40 or thereabouts, pulls the limousine around. He's been trying to get contact with someone. He pulls around up to the Rockingham gate, which is on this side, as opposed to the Ashford gate, which is on this side, and then he apparently then goes back. You know, having heard his testimony read at both the preliminary hearing and the grand jury, not looking for and cannot tell us either way whether the Bronco is there or not. He goes back to this location, and that's about 10:40 or thereabouts at Rockingham.
E131,
All right, at 10:40, we have Mr. Heistra still in this alleyway, this area. This is approximately the time at 10:40 p.m., June 13th, that he hears this confrontation, supposedly with these men's voices, the sounds, etc., and the distance that he's away.
E132,
All right, at 10:45, there'll be testimony, I believe, that Alan Park is up to the gate at this point, that you see the location of the other parties, their location. He's closer to the gate with the car right at the gate. You see the position of the other parties at that time. He's moved his car back from down at the Ashford gate back around. It's 10:45 or thereabouts.
E133,
10:45. This is the journey of Mr. Heistra as he's continued down this alleyway. See where he's gotten now as he's walking the dogs. And he's still walking parallel to the residence, having made the observations that I've shared with you earlier.
E134,
10:50 or thereabouts. Mr. Simpson, the evidence will show, has come outside of his residence. He's gone over to the Bentley at that point. Look inside the Bentley, and this location here, it's a white car, a white indication there, but that's supposedly Bentley at that location. Simpson's outside the residence. Park is over at the gate. Lopez is back in her residence. Cato Kalin is still somewhere back in his quarters, apparently, at that point.
E135,
10:50 now at the Bundy address. There are no witnesses at this particular point.
E136,
Now, 10:55. We now have Mr. Simpson having been or done whatever he was doing in the area of the Bentley, going back over toward his house, to get his luggage and come down to get ready to leave. You have Cato Kalin coming out, presumably because he's heard whatever noises. He's now outside of the location. Alan Park is still over here. There's some testimony there'll be some golf clubs or whatever out here in this area of the yard in this area here. All at Rockingham. This is approximately 10:55, just before 11.
E137,
The scene remains pretty much the same. Robert Heistra is now out of the scene here at Bundy.
E138,
11 o'clock, Alan Park is let in. Your testimony, I think, will be that they start to load the limousine up, which is now inside here. Cato Kalin is having conversations with O.J. Simpson about noise that he's heard. He's trying to get a flashlight. He's trying to tell Mr. Simpson about what he thinks he's heard. Mr. Simpson is rushing around at this point. At some point, he goes back out. He goes to the Bronco at some point, comes back in, gets his luggage and brings his luggage down, the number of pieces of luggage which you'll hear about. And all of these people in and around 11 o'clock and thereabouts playing, or in this particular area here, is depicted on this exhibit at Rockingham. Mr. Harris? Situation remains the same at Bundy. And so at Bundy, no other witnesses at this point. Mr. Harris, will you go back to Rockingham at 11 o'clock? Cato Kalin's car remains in the same place. The limousine is now closer in the Ashford Gate. Bentley is still where it is. Bronco is still where it is. Ms. Lopez is in her residence. Kalin, Mr. Simpson, at or around this area with Mr. Park. As I've indicated, this is the time that they're preparing to go on this pre-scheduled trip to the airport to go to Chicago. Around this time or thereabouts, Mr. Simpson has come out and gone out to the Bronco, and then he comes back in also at that point. I've taken this from 9:45 until 11 o'clock because that's the time the prosecutor referred to and talked to, and I think it probably is the very appropriate time for us to look at. In discussing this particular timeline, I tried to demonstrate for you the witnesses that we expect will be called, what they have to say about this particular period of time. In listening to the prosecution's opening statement, they claim that Mr. Simpson left the Rockingham location, traveled to Bundy, killed 2 people with 1 knife, hid the bloody clothes, and returned to Rockingham. He did all this at about 10:15 or 10:15 and got back there at 10:25 or 10:30 or something of that nature. In a short period of time, that's what their theory was. We think that they have further, based upon their opening statement, committed themselves to a theory that in traveling to and from Bundy, Mr. Simpson had used this Bronco that you've heard so much about. So therefore, wherever that Bronco was that night, then according to their theory, that's where Mr. Simpson was that particular evening. What we tried to demonstrate for you in the evidence, we think will show, there's not that window of opportunity. There's not the time at which they can prove that Mr. Simpson committed these horrible crimes. They don't have the time, the opportunity, nor the motive to establish this. We think the evidence will show that he did not, could not, and would not committed these particular crimes. Now, in the course of this trial, you will hear some testimony regarding domestic discord, domestic violence, if you will, about what happened. I touched upon that briefly the other day. Without belaboring the point, and as you hear this testimony, I ask you, as with all of the evidence, to keep an open mind, to remember that the incident, January 1st, 1989, was the assaultive incident that Mr. Simpson took blame for, wrote letters of apology. And you recall the testimony we expect to be she was never struck after that in any physical sense, and that, in fact, he made an agreement regarding the prenuptial agreement, that if there was any physical touching, the prenuptial agreement would be voidable at any rate. That was never done. We expect to show that with regard to this entire domestic discord evidence, that there will be, and I ask you to bear in mind, in many instances where there are more than one person present, please keep an open mind until you've heard the other people who are also present at these incidents, so you can make a determination of whether this has any bearing at all. Because if you follow the evidence, and if you believe that Mr. Simpson could not have done this, that this timeline is such that there's no time for him to do it, no indication that he could have done this, that the Bronco was still there, whatever, then the character evidence would mean absolutely nothing. Because how could you then predict that someone who gets into a fight with his wife in 1989 will then kill her in 1994? One area that I did not cover earlier is the searching done in this case. They've searched everywhere in this case for weapons and or clothes, and I think the evidence will be that they searched even in Chicago, in the fields and the wooded areas in Chicago, all up and down Rockingham and Bundy and every place they possibly could. They worked very hard on this case because in their rush to judgment, they fixed on this one individual, and that's what they focused on, and we think the evidence will show that that's exactly what they did. Ms. Clark in her opening statement said that Mr. Simpson's time was unaccounted for, quote her, from 9:45 till 11. I think you'll find when you hear the evidence that he spoke to the police. This time is not unaccounted for. The time will be accounted for. That concludes your.
Now, why don't you approach the bench with the report, please?
Now, I think when we stopped, I was addressing the issue that we think the evidence will show that Mr. Simpson's time will be accounted for and not unaccounted during this particular period of 9:45 to 11 o'clock. In looking at my remarks the last time I spoke to you, I noticed that I misspoke when I said at one point that Dr. Carey Mullis had won, I think I said, the Nobel Peace Prize, and I think I must have had Dr. Martin Luther King on the mind when I talked about him. He won the Nobel Prize for chemistry. I'm going to clear that up. When I was addressing you about the prosecution's theory a few moments ago in this case, I recall that Ms. Clark had indicated that the time of death was 10:15 based upon the wheel of the dog. As to the time she alleges that Mr. Simpson got back to the premises, that'll be up to her to prove, and I suppose that I shouldn't speculate with regard to that. Now, I'd like now for Mr. Douglas to bring some charts up that relate to certain jury instructions, which I think would be very appropriate for you to have in mind, as with all of the jury instructions that the court has given you, with regard to the evidence in this case and how you're going to go about your task of rendering a decision now that you have an overview of this evidence. We'll have 4 charts that I'd like to step down. Now this chart is 2.20, which is the CalJIC, the jury instruction. I think you've already heard it. And the reason I wanted to point this out to you again is that as in this case, and in all criminal cases, this is kind of a guide for you to look at the witnesses who get on the witness stand to help you in determining whether or not you find that particular witness to be credible or believable, if you will. And they set out certain things that you might look at. Look at things like the ability of the witness to remember or to communicate any matter about which the witness has testified, the character and quality of the testimony of that particular witness, the demeanor, how that witness acts on the stand, and the manner of that testimony, the existence or non-existence of a bias. Does the witness have any interest or bias in this particular case that you're looking at? So the attitude of the witness toward this action will be things that you'll look at. And the court has read this to you in the character of the witness for honesty or truthfulness, or any statement previously made or whatever. These are the things that I would ask you to use with regard really to all witnesses called by prosecution or the defense. Remember, that no side has a claim to the truth in this case as we go about this search for truth. People have been talking about it. The next jury instruction, and that is number, Mr. Douglas, number, get the number, Your Honor. Okay, like that, huh? Number 215. And number 215 is the so-called alibi instruction. And you'll recall that I asked you in voir dire a long time ago that you would not put any bad connotation on the term alibi if that's what the law calls it. That no matter who is charged with a particular offense, if you were someplace else, you produce evidence that you were someplace else, the law calls that an alibi. And essentially this instruction says that the defendant in this case actually will be introducing or expects to introduce evidence for the purpose of showing that he was not present at the time and place of the commission of the alleged crimes in this case for which he's here on trial. That if after consideration of all the evidence you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Now again, this instruction is important like all the rest. But the alibi instruction, if you establish the alibi to your satisfaction, be entitled to an acquittal under those circumstances. I'd ask you to think about that through the coming months as you listen to this evidence.
Exhibit 216.
Mr. Douglas? You recall all of the examples we used during voir dire again about direct and circumstantial evidence. Well, in the final analysis, this is a case that will rest primarily on circumstantial evidence, and you know what that evidence is. And there's a jury instruction that applies to that. It's extremely appropriate, and I think I applaud Judge Ito for having given you this instruction early on, because I think it's very, very important for you to be aware of this as you consider this evidence, especially circumstantial evidence, and how it will be applied at the very end of this particular case. This is part of that instruction, and the relevant portions would be as follows: that a finding of guilt as to any crime may not be based on circumstantial evidence, unless the proof circumstances are not only one, consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count, there are two counts here, susceptible to two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. So after you listen to this evidence, as we think the evidence will show, and you have a belief that Mr. Simpson did not go back over to that location, didn't go to the location, that he was never, that his Bronco never left the premises that night based upon.
Your Honor, this is all argument.
Well, let me phrase it this way.
Please.
And the
Objection.
counsel instruction is not ready to be read.
I'm going to get to it. If after you heard all the evidence, and you know what circumstantial evidence is, you will then be in a position to make a judgment as to whether it applies at this particular point. Without arguing what it is now, we'll have a chance to argue at a later time. But the point that I wanted to make at this point is for you to understand what this instruction would be as the court has. And lastly, as Ms. Clark points out, if on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. It seems reasonable, doesn't it? But the point is that you, no one else, will be the sole and exclusive judges of the facts and the weight of evidence. That's the determination that you must make. And no one can tell you what to make in that regard. And each of you in voir dire has promised to give us your individual opinion in doing that. And the last jury instruction
Exhibit 217, Your Honor.
is the so-called presumption of innocence, reasonable doubt, and burden of proof instruction. That's the last instruction I want to leave with you today. A defendant in a criminal action is presumed to be innocent until the contrary is proved. In the case of a reasonable doubt, whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. And this presumption, of course, as you know, places upon the people the burden of proving him guilty beyond a reasonable doubt. And reasonable doubt has been defined as follows. It's not a mere possible imaginary doubt, because everything relating to human affairs, depending upon that everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case where, after the entire comparison and consideration of all the evidence leaves the minds of the jurors, in that condition that they cannot say, they feel an abiding conviction of the truth of the charge. Now that's what reasonable doubt is in this case, in every case. And I wanted to make sure that you, again, are aware of that as you listen to this case. This is a murder case with two charges, two counts. This is not a domestic violence case. Now, as we conclude, and finally, as I promised you today, I believe the evidence will show that we expect also that there will be evidence and testimony that a short time before Mr. Simpson went to Chicago on Sunday evening, June 12th, I think on or about June 2nd, his secretary, at his request, ordered this Star 69 feature at his request on his phone. And we expect there'll be additional testimony about that and as to why that was. In summary, as you then look at all the evidence in this case, we expect the evidence will show that O.J. Simpson, as you see him there, is not a perfect human being. He, like all of us, has made mistakes. Of course, we know there's only one perfect person who ever walked the earth. We think the evidence will show he's not guilty of these horrible crimes, that he has been blessed bountifully by God, and he shared his largesse and blessings with many, many people. That in this instance, prosecutors' theory that there was only one murderer is just theory. We expect to introduce evidence to show there was more than one killer, and that the prosecutor's theory will be overcome by the facts which we present. We also expect that the evidence to show that the reason the prosecution maintains there's only one killer is that Mr. Simpson, whom they want to portray as a stalker, and stalkers don't come in pairs. There can only be one person under that scenario. That ex-husbands who are stalkers don't come in pairs, and that's why they're wedded to this one murderer theory, even contrary to what their own coroner may very well indicate. I've shared with you also the fact of Mr. Goldman's journey that evening, and when he checked out and went home and changed clothes and everything, so I will not belabor that. We expect there'll be evidence about how you get into 875 South Bundy when one comes up and rings the bell or whatever, how you get in from the house or whether that's possible, whether somebody has to let you in or how you get in the particular residence. I've already told you we expect there will be evidence of the size of this area, and I think Ms. Clark has indicated, and I think the evidence will show, it's a very, very small area given the circumstances. We will show that the police who came over to Bundy, you will see walking through that scene, went in that house and didn't take one picture. They went in the house, that they found candles burning and various other things, that the investigation inside that house was shoddy and scarce, if at all, under the circumstances. And so in this case, as with many cases, you'll recall that we talked to you a lot about truth and your common sense. During voir dire, I think all of us told you that we wanted you to use your collective common sense. And don't leave it outside in the hallway, to bring it in and apply it to the facts of this particular case. In applying that common sense, as I indicated to you, you'll look and you'll be able to see this small area. You'll see the fight that Mr. Goldman put up. You'll see the injuries that he sustained. You hear the testimony about the amount of blood to be expected on the perpetrator. You've seen Mr. Simpson's body, the lack of scratches thereon. You'll see, and your common sense will address, based upon the evidence, the issue of whether one person could kill two people under these circumstances without hearing screaming and a lot of running and all sort of things. We expect, hopefully, that the evidence presented by the defense will help you provide some answers to these common sense questions. Expect also that you'll hear from a witness by the name of Paula Barbieri. She's, both sides are aware of it, and will testify about her relationship with Mr. O.J. Simpson. Specifically, as I mentioned earlier, between the period May of 1992 and May of 1993, and May of 1994 to the present. This case really boils down to a whodunit. That's what this case is about. It's not about domestic violence or whatever. It's about who killed these two people in these particular horrible crimes. The prosecution will probably start off with the domestic discord evidence. And that, with all the evidence, I ask you to keep an open mind. You know the circumstances. You know there are generally two sides to every situation. We cannot call our witnesses till we get our time in the part of the case where it's our time to put the witnesses on. That's why I've spent so much time in this opening statement, to try to detail for you what we expect the evidence to be and what we expect to show. You understand that the fact that someone has an altercation with one's wife in 1989 is not capable of being predicted whether that person will kill her, be involved in any other fights, or whatever.
Sustain.
And so I started off by indicating to you that I thought this case would be a case where we would establish this was a rush to judgment by the prosecution, and they had theories and speculation. We would have the facts.
I assume these are the concluding remarks.
Yes, Your Honor.
Thank you.
Thank you. They would have theories and speculation, we would have the facts. That I was trying to conclude what I was saying when she interrupted me. In this instance, in this case, both sides are interested in this search for truth. That's what a trial really is. It's a journey for truth, for you to determine the true facts of what happened on June 12, 1994. We spent a great amount of time in selecting each of you for this task, because we knew it would be a very significant task. And in truth, I'm always reminded of something that James Russell Lowell said. The truth forever on the scaffold, wrong forever on the throne. Yet that scaffold sways the future, and beyond the dim unknown standeth God within the shadows, keeping watch above his own. And in this case, God knows what happened on June 12th.
It's argument, all of it.
This is not argument, Your
It's a
Honor.
closing comment. Thank you, counsel.
Thank you. God knows what happened on June 12th, 1994. And we hope that after you've heard all the evidence in this case, you can make a rational decision, and you too will know what happened. And you will know that O.J. Simpson,
Objection,
He can say that that's what he intends to prove, counsel. He can say that.
thank you, Your Honor. And you will know that the evidence will show that O.J. Simpson, that man pictured over there on June 12th, did not kill his wife, did not kill Ron Goldman. And he is entitled to an acquittal. Thank you very much for your attention. It's maybe the longest opening statement in the history of this building. But I appreciate your patience and the fact that you took the time to listen. Thank you.
All right, thank you, counsel. Deputy Magnera, we're going to take a break. Let me see counsel without the reporter before we do that, though. All right, ladies and gentlemen, we're at that part of the trial where we will now this afternoon start the presentation of the witnesses and evidence to you. As I mentioned to you, that before we actually started the presentation of the witnesses, we needed to do a little moving around of materials and things here in the courtroom. We're going to do that. I expect to start with the witnesses in about half an hour. All right, so I'm going to excuse you to go back up to the lounge. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions. Don't talk to anybody about it. Let anybody talk to you. And we'll see you back here in about 30 minutes. All right? All right, counsel, I'd like
He made other statements to other parties indicating that she had no awareness of any unusual events that transpired that night, and that her story was so incredible that when she attempted to sell it to the National Enquirer, they declined to print it. And that we would have told the jury about all of these things, about these witnesses, had we been informed.
We're going to have a trial about the credibility of the National Enquirer?
No, we're going to have a trial about the credibility of witnesses who are so uncredible that even the National Enquirer would not use their story.
That's hard to believe.
It tells you how uncredible, but it certainly tells the court how uncredible that witness is, if even they decline to use it. And that we would have informed the jury of those witnesses and of those facts, but we were unable to do so because counsel willfully withheld them. Thirdly, with respect to the rheumatoid arthritis, the chronic and acute phases described by counsel, that again, these witnesses were not disclosed to us, and no statements were disclosed to us indicative of the possibility that they would be called for the purposes outlined by counsel. And had we known, we would have shown them the videotape of the workout tape made by the defendant 2 weeks before the murders, and we would like to show them some of the outtakes of that videotape. And finally, to correct counsel's entirely misrepresentative statements concerning the EAP markers on the victim's blood and victim's thigh and onto her nails. Counsel misrepresented the nature of the report to the jury in a manner that is so confusing and misleading that if we have to wait until that testimony is forthcoming, the jury will be hopelessly lost. The problem is that we have a diametric opposition between the report and what was actually said to the jury by Mr. Cochran. The report indicated that the B-type that came up on EAP marker was inconsistent with any of the three parties, and went on to state, which is what Mr. Cochran never let the jury know, that That did not rule out Nicole Simpson as a possible source because her type being a BA, this is a very labile marker, which means that, in essence, the A falls off when there's degradation. That there was, in fact, evidence of degradation of this blood because her hand was found clutching her neck under her body where the blood was warm, very wet, and very subject to degradation in a rapid manner, which is what caused the degradation from BA to B, and that's what the report reflects. Moreover, counsel directly misrepresented the conclusion of the expert with respect to the blood on the thigh. That blood indicated a faint A activity. It was a faint A activity that is indicative of the possibility that it was her blood, it was consistent with her, and so the conclusion was inconclusive, not that it was not consistent with her at all. So right now the jury is sitting there having been totally misled as to the nature of the findings. Not only that, and misled as to the contents of the report because counsel excerpted portions unfairly. I understand counsel doesn't have to read the whole report, but it should be read with respect to all of the conclusions, not just the one that suits counsel with respect to this particular item of evidence, and that's what was unfair. We would ask leave of the court to inform the jury of the fact that they were misled, that the report actually states as follows, and to highlight all of the portions. At this point, Your Honor, counsel's statements to the jury have caused, because of the national televised nature of this trial, the whole country's been misled as to the truth. The truth has been hidden, has been obscured by counsel willfully. Counsel knows the truth. Counsel knows what we have in this blood. Counsel knows that the PGM subtyping has shown that it is her blood. And counsel knows that tests are ongoing that will further establish that it is her blood under her nails and on her thigh. But we have a whole nation now who has been misled as to the nature of this evidence. But more importantly, that this jury has been willfully misled and been made to believe that the conclusions were diametrically the opposite of what they really were. So we would ask leave of the court to address the jury with respect to that item as well.
Let me ask you this, Ms. Clark. Let's take it from the top. As to Ms. Gerchis, there is the claim of right to reopen since there was no notice given of this person's statement. This is the person who was alleged to have seen 4 individuals in the vicinity leaving the scene roughly at a time consistent with this particular crime, so obviously this is an important witness if this testimony pans out. What, in your offer of proof, do you believe shows lack of credibility and would be admissible as impeachment evidence? I mean, you've given me the fact that somebody has 34 pending lawsuits against them doesn't necessarily mean that they're not a credible person. I mean, they could be all car crashes for all we know. I don't know.
May I address the
I mean,
court?
other statements that are inconsistent, that sort of thing. I mean, that's a different issue. It has to go directly to credibility, other bad acts.
Mhm. Yes, I appreciate that, Your Honor. With respect to those lawsuits, we will be calling witnesses to testify to the fact that they were for fraud, which does go directly to credibility.
How many of these lawsuits are actually final with judgments rendered against Ms. Gerchis for fraud or fraudulent activity? Because I'm not willing to litigate 20 other lawsuits if there isn't some verdict in them.
We could simply call the parties to the lawsuit to indicate why they've sued her. They would indicate that, I believe with respect to almost all of these lawsuits we're talking about, all 34, they all deal with fraud and misrepresentations in the operation of her business. And
Well, do we know how many of these have resulted in verdicts?
I'm sorry? I can't hear you. Counsel's talking so loud.
Do we know how many of these cases have resulted
May
in
I
adverse verdicts?
may I
Certainly.
inquire, Your Honor?
Certainly. Judgments, verdicts, same thing.
We have,
Not for this purpose.
because counsel has hamstrung us by hiding this witness, we have not had a great deal of time to complete the investigation. And we have obtained a list of all of the, what Mr. Darden is holding right now, a list of all the filings that have been made against her, but we have to investigate each and every one to determine the resolution of each one. If counsel had given us this information in a timely fashion, Your Honor, I could have stood here before the court and explained and given the answers to all of this a long time ago. But it's been 7 months since they took the statement, and we just got the notion of her existence last week.
Well, Ms. Clark, then, since these revelations on Wednesday, you haven't sent a law clerk over to the Civil Index to go check the status of all these cases?
We are checking many different, we are making checks on all of the representations of counsel. There is a lot to check, Your Honor, and with Rosa Lopez as well.
Wouldn't you say this is a key, rather key place where you should focus your effort?
It's one of them, yes, and we have been. We have investigators out right now, and we have had. That is one of the many areas regarding Ms. Gerchis that we are investigating. But there's a lot to investigate in Ms. Gerchis, a lot. Not to mention the 3 Social Security numbers, the 3 phony names. Right in front of us, we have 4 judgments shown. And we have additional paperwork that we're going through upstairs as we speak.
So what are you asking for me to do? To delay these proceedings until you complete your investigation?
I don't think it's asking for very much to ask for some additional time to be able to present to the jury an opening statement that comprises all of the facts, since it is not our fault that we didn't have time to investigate this person.
All right, let me ask you about Rosa Lopez. My recollection is that her name does appear on the defense witness list and that you did have information regarding her previously. Is that correct?
Yes, we had limited information regarding her. We have new representations made by counsel that indicate that there are other statements that we are not in possession of. The actual statement given to us by counsel indicates that what she told Detective Furman was that she heard some noises last night. That's all it says. Counsel made representations that she told Detective Furman that she was out at 10:15 and saw the Bronco on Rockingham, that she was out earlier at 8:30 and saw the Bronco on Rockingham, that Detective Furman was in possession of all of these facts and all of those details, when in fact their own witness statement indicates only that she told Detective Furman she heard some noises last night, period. No mention of a Bronco, no mention of being out walking her dog, no mention of seeing the Bronco anywhere.
When did you receive this
That statement?
statement?
September 1? So what counsel represented as having been stated by this witness to the jury is not at all what was contained in the witness statement that he gave to us.
All right, here's one of the difficulties, Ms. Clark. You're arguing Rosa Lopez. This is the first argument regarding Rosa Lopez from the prosecution point of view. She was not part of our discovery sanctions motion, to my recollection.
She wasn't.
She was not.
No, I know. I know, Your Honor. Yeah. We had to go through the transcript. You have to, Your Honor, when you tell us to go and do something, it doesn't just happen like that. We have to go up and we have to work. We have to go through the transcript. We were up all night.
Counsel, here's the
And
problem.
what we found is that when we went through the transcript, we found that there were many different statements attributed to her that we did not have.
Here's the problem. We took our recess to do that. I asked you to go through the record and find all of these discovery transgressions that you could find. The problem that the court has is I'm just the referee here. I'm not privy to what information either side has. You know the details of your case. You know what you have in discovery. I have no idea. I went through the record. I found the names of the 14 witnesses whose statements were given over last Wednesday. I went through the record and found the expert witnesses who were discussed that had not previously been disclosed, or it was unclear from the record who they were, and those that you objected to. Now you're raising an additional objection to Rosa Lopez that has not been litigated, and you're raising a different objection to the Mr. Cochran's statements regarding the EAP blood typing, correct?
Yes, well, I
neither
raised
of neither of which was discussed previously in our sanctions motion, correct?
I did object on the blood before. I did. We went to sidebar, and I made an objection on the record to the court concerning the misleading nature of counsel's remarks. I'm on the record with respect to that, Your Honor, at sidebar. And,
But see,
Yeah.
part of the problem is that was part of our show and tell, where that was exhibited to you, and you had no objection to that exhibit. That's why I overruled your objection. There were 2 days where counsel exchanged exhibits, showed them to each other, and it was a little late in the middle of counsel's opening statement to then start lodging objections to an exhibit that both sides had seen and had waived any objection to.
I
That's
didn't,
the problem.
no, but I did not realize that counsel was going to excerpt a half of a sentence, which is what he did. I'd like to, if I may, Your Honor, I'd like to show the court what I'm talking, because the court doesn't realize there's a paragraph. Counsel took out 2 lines from that paragraph, and it actually is, I think the court should see it, I really do. I think that if the court sees it, it will realize I was misled. I thought this entire paragraph was going to be shown. If it had been, I wouldn't have objected, but it wasn't. As a matter of fact, another thing that happened, Your Honor, was that I was shown the front page of the coroner's transcript, and I believed that that one area was going to be highlighted for the jury on that front page. And lo and behold, in front of the jury, I see counsel going after page after page after page, which I was not told about. I didn't bother to object because I didn't want to interrupt the opening statement any more than I needed to. But as a matter of fact, I was misled, both with respect to this and with respect to the coroner's report. Counsel put in a lot more, or in this case, a lot less, than what I was led to believe he was going to do.
Well, Ms. Clark, let me ask you this, though. After we spent 2 court days doing a show and tell, and you waived your objections, I mean, how am I supposed to go back and now revisit this and allow you to reopen opening statements? Because so far, the only thing that we've talked about that remotely approach being able to reopen on are your comments as to Ms. Gerchis, as to judgments against her, and the exercise video contravening the arthritis experts that had not been previously disclosed. But Rosa Lopez is an objection just now being raised, and the EAP is something, although you did raise that objection earlier, I think you waived that objection having passed on the exhibit.
I didn't pass on the exhibit, Your Honor. That's the problem. That's what I'm trying to explain to the court. Number one thing, let me get back to Rosa Lopez. As to Rosa Lopez, she was mentioned by counsel
No, no.
today.
If you're really
So-
worried about the EAP, let's quit jumping around. Tell me about the EAP and why you feel you were misled.
I think what the court doesn't remember is that we were supposed to have show and tell on Friday, and counsel only showed me a tenth of what they had. We came back in on Monday, and at the 11th hour, before we were to begin our opening statements, counsel sprung 20 new boards on us and then pulled out the reports. Those reports were not shown to me on Friday. And to the extent that I was shown the reports, the coroner and this one, I was misled as to what they were going to use. And only when it was showing before the jury did I realize what he intended to do. I made the objection as timely as I possibly could. The moment he did it, I was overruled. Nevertheless, I was misled. And if I show the court how this paragraph appears, I think that the court will understand why I was misled. Counsel pointed to this portion of of one particular result on this page, and I believe that it was going to be fairly exhibited to the jury in context.
All right, why don't you read it for the record?
You know what? If I could use the Elmo, I can show it and read it at the same time.
By golly, let's do that.
The part that I've drawn, Your Honor, the bracket around, that's the item in issue. Item 84A. I need one. And 118A. Could not have come from Nicole Brown Simpson, Ronald Goldman, or O.J. Simpson. However, Nicole Brown Simpson cannot be excluded as a source of the stain if the EAP type B observed on the items were degraded from a type BA. Now, there will be substantial literature, Your Honor, to the effect that a type BA...
All right, let me see. Mr. Harris, is he available?
Your Honor, we went through all the laser discs, and we only had the highlighted portion portion that we show on two boards, one with the cover highlighted and then pulling out the highlight. We only showed the laser board. All of our presentation was shown.
Your Honor, I don't even remember seeing a laser on this. All I remember having counsel tell me was showing me a report. You know, I would not have taken counsel to sidebar and objected to something had I known what he was going to do. As a matter of fact, I would have objected strenuously ahead of time had I realized that he was going to take one line out of context, outside of a paragraph.
All right, you understand the difficulty I have here. I mean, you've been given an opportunity to litigate it, now you want to come back and do it again. That's my problem. Where's Mr. Harris?
I'm going back to the office, Your Honor.
About the laser disc would be used in reopening, should you permit it.
All right, Ms. Clark, there's really something that I can't deal with then if the laser disc itself, the exhibit that they showed you, is in fact gone, because I need to make a factual finding as to whether or not there was some, that you were misled in some way as to what it was.
I'll tell you that, Your Honor, I don't recall seeing a laser disc.
Well,
There was,
Ms. Clark, let's look at the laser disc and see what's there, because that's pretty much frozen in its state. You know, that's not easy to manipulate, so let's take a look at it. Unfortunately, we probably won't be able to see it for quite some time. Since Mr. Harris is on his way, we'll have to catch him and bring him back.
But, Your Honor, I can represent to the court that we did not have the document here on Monday. We had only the laser disc, and the court required that we go through and show everything.
Which is why, Mr. Douglas, I'd like to see the laser disc.
but why was it only being shown to us on Monday? Why wasn't it shown to us on Friday?
No.
No, I'm
Ms.
serious.
Clark.
You know something, Your Honor? This is very unfair. The defense was required to show all their exhibits to us on Friday, as we did for them. We sprung nothing on them. They came marching in Monday with twice as many exhibits as we were shown on Friday. We were expected to absorb everything in a nanosecond and come up with cogent objections to each and every item. And that's very unfair. The people were put at a great disadvantage at having to absorb a great deal in a very rapid amount of time and come up with an objection as to each and every item. I don't think it should be all that surprising that I couldn't remember seeing one of about 50 new exhibits that was thrown at me Monday morning before our opening statements were to begin. And that alone should cause the court to realize that the people were put at a disadvantage with respect to being able to make intelligent objections to all of the wealth of new information that was unjustifiably thrown at us at the 11th hour. We should be given more time at this point.
Did you ask for any additional time at that point?
I did, and the court was... I indicated to the court at the time, Your Honor, that I did not have an opportunity to examine it carefully, and you asked me to immediately go through board by board and exhibit by exhibit with about 10 seconds for each. There really was not a lot of time. The court is concerned, I understand, about having the time of the jury spent fruitfully, and I'm mindful of that, and I appreciate that. And the court, was feeling the time constraint, understandably so, and so was I. But the result of what has been misconduct by counsel in failing to turn over exhibits in a timely fashion should not inure to the people's detriment, as it has been. And I think that's very unfair.
So you're saying that last Monday, the 23rd, just so I can check the record if I have to. All right. I'm not going to take up that issue unless and until I see the actual Laserdisc exhibit, which has unfortunately left the courtroom. That leaves me with Gerchus and the arthritis experts.
Okay, and with respect to those witnesses which the court knows we were not informed of, either their names or their statements or their proposed testimony, we would ask leave of the court to address the jury with respect to the fact that we were not apprised of their intention to call such witnesses to describe the defendant's physical condition at the time of the murders, and that had we known, we would have discussed that with the jury at greater length, putting on the exercise tape. Now, counsel showed us photographs of the defendant's body that they intended to introduce, But those photographs gave us absolutely no notice that they were going to be presenting testimony concerning rheumatoid arthritis. The existence of Howard Weitzman, that was another matter that was not turned over to us in discovery. The name was not even on a witness list. Had we known that they would make these representations to the jury, that Mr. Weitzman was excluded from the conference room, we would have been able to address the jury on the fact that not only did that not happen, but the officers are very well aware that would be a violation of law. As a matter of fact, it's something that is contained in the Miranda advisement, that Mr. Weitzman was in fact pointedly invited in with Mr. Simpson, that he declined to remain with Mr. Simpson, and himself decided to leave the facility. And we would have told the jury all about that. We would have even maybe read the Miranda advisement to the jury so they can understand that this is an obligation of the police to afford anyone who appears with his attorney the right to have the attorney present during questioning, and that Mr. Simpson was so advised, and that he elected to proceed without the presence of his attorney, and we could have done all of that. But counsel, as a matter of fact, we have that waiver on tape. Counsel's aware of that. But yet counsel deliberately chose to make a statement that was false to this jury concerning Mr. Weitzman. Had we known he intended to do so, and had we known that Mr. Weitzman intended to so testify, we would have put that before the jury. Furthermore, all of the evidence with respect to the circle of benevolence, the charity, and the gift giving, we had no discovery of any of that, Your Honor. That defense counsel wanted to present that. And with respect to at least the representation of anonymous gift giving to links, we believe that we will have evidence to demonstrate that to the extent money was given, it was not anonymously given. And we would like to present to the jury the fact that the amount given to charity was minuscule compared to the amount of net worth this defendant had. And so we would like the opportunity to counter some of that evidence, which was also still has not been turned over in discovery. Still, only knowledge we have of that is the representations of counsel in his opening statement to the jury. Furthermore, with respect to Skip Taft, I believe counsel, again, this is another name that was not put on the defense witness list, for whom we have no statement, but counsel represented that Mr. Taft would testify concerning the contents of a prenuptial agreement.
Is there any dispute about that?
I believe there is. May I have another round? There were certain representations made with respect to what Skip Taft would testify to in that prenuptial agreement, that he would testify to the circumstances surrounding it, and it was represented to this jury as being another act in the circle of benevolence, that in fact it was a civil compromise attempt and nothing more by the defendant in an effort to get to pressure Nicole to withdraw her support for the prosecution of that case. And we would like the opportunity to address the jury as to the truth of the circumstances under which it was written. I just can't, it doesn't come to mind at this moment. But that's for starters.
Mr. Bailey?
If it please the court, in asking this court to set what I think would be a precedent in criminal cases, the prosecution now wishes to escalate that remedy to a full-blown rebuttal of things they wish they thought of when they gave their opening statement. They knew before they opened that Mr. Simpson intended to exhibit his scarred and torn-up knee to the jury and claim that he was disabled to a degree. They had the exercise tape. They elected not to play it. Now, in retrospect, it seems a bad idea that they didn't. Since you have stricken from our opening the names and any summary of what they might say of the witnesses enumerated in your order, it seems to be most anomalous to silence us and let the prosecution get up and trash them without rebuttal, making wild statements like Rosa Lopez is an O.J. Simpson fan when she's never met him, or Nicole. Furthermore, all this claim of surprise on Rosa Lopez is totally incredible. You will recall that as part of our offer of proof in response to the government's demand to you, we cited two preliminary incidents, both occurring on the 13th, which showed bad faith on the part of Mark Furman. One was the glove, and the other was suppressing a statement that Rosa Lopez had given him. It was in the papers. It was faxed to the government on Sunday the 8th. It was argued orally here, and was in part, I guess, the basis for your ruling, together with the Anthony case. Mr. Cochran, long after the statement was taken and before this representation was made to the court, personally wanted to verify that she claimed that she had made those statements to Furman. And on that basis, we asserted it to Your Honor. I never heard it denied in the course of the whole argument. I don't think Rosa Lopez is any part of any reopening. Perhaps, perhaps as to Gertjes, if some admissible information can be gotten, the court might permit this now thoroughly trashed woman, who's never had a day to appear, although she's expressed an interest in doing that, to be impeached. If, in good faith, they claim, and they, as officers of the court, assure you that they will produce on the witness stand under oath people who will testify that she has made the statements attributed to her. I'm not talking about judgments now or check cases. I'm talking about impeaching statements. If those representations can be made in good faith, perhaps, Your Honor, might permit them to talk about it. I haven't heard another thing in all of Mrs. Clark's presentation that makes any sense at all as reopening as a remedy for the sanctions, as part of the sanctions you've imposed. Insofar as the blood evidence is concerned, we have an assertion of fact could not have come from Nicole Simpson, an attempt to bail out by somebody who obviously is in the prosecution's corner, speculating that if the blood were degraded, AB might have shown up as B, and therefore that would explain it without bringing in another party. We showed that on the screen. It's in the statement. If we had it to do all over again, I don't think any court could compel us to link the author's speculation with his established fact, and that's all that second sentence is. We pay it no importance at all, and we don't think that it's going to pan out. But in any event, in opening statement, we're entitled to show the jury those things that favor us. Now, apart from Ms. Gertsch's, I don't believe Your Honor should permit any of what has been requested by the prosecution. It is nothing more than a chance to come back and rebut the defense opening statement. They could have handled all of these matters beforehand if they had thought about what they were doing as carefully as Mr. Cochran did when he laid out his very detailed presentation.
Ms. Clark?
With respect to the blood argument just given by Mr. Bailey, he demonstrates nothing but his ignorance. As a matter of fact, what Mr. Matheson put in that report is a matter of established science. We are talking here a matter that is the subject of treatises that are many years old. It is a known fact that the EAP marker is very labile, that a BA degrades to a B very rapidly, and the court can envision it. You have 4 bands in this marker: heavy band, faint band, heavy band, faint band. The faint bands are A, the heavy bands are B. The faint band, being A, degrades first. BA goes to B very rapidly. It's a known thing, which is why when there's evidence of degradation and you have a B result on the EAP, you cannot exclude the BA. And that is something that the jury has been completely misled about. Not to mention the fact that at least on the thigh marker, where counsel told the jury that it excluded her as well, there was faint A activity. So, I mean, there's been a...
I'm not prepared to really make a ruling as to the blood issue until I see the Laserdisc exhibit to see whether or not there is some real danger of the jury having been misled there. I'd like to hear your observations on Mr. Bailey's argument that you were aware that there was going to be some allegation that Mr. Simpson was unable to, because of his arthritic condition, unable to physically to even contemplate committing these acts. Why it didn't occur to you, knowing that, to play the exercise video during your opening.
When did we know that, Your Honor? When does counsel allege that we knew that?
When the motion was made for the defendant's right to address the jury during opening statement.
Which was on Monday.
Right.
Which we objected to.
Before your opening statement.
That's right, which we objected to. But being able to show a scar, which is what my argument was to the court at the time, has nothing to do with doctors who are going to testify to rheumatoid arthritis. There was no offer of proof forthcoming with respect to how that scar was going to be linked up. I repeatedly argued to the court, what is the probative value of showing the jury a scar? Believing that that's all that the defense would do, I elected at that time to let it be. Because I did not think that counsel, because counsel did not give us discovery. This is the problem with being sandbagged, Your Honor. Counsel never gave us discovery of the fact that the doctors were going to be rheumatoid arthritis specialists, were going to come forward and link up that scar to something meaningful in terms of his physical capabilities on that day. And counsel deliberately and willfully did not inform the court or the prosecution of his intent to link up that scar to a doctor's testimony. Now, how was I able to anticipate what counsel was going to do when he willfully withheld that information?
All right. Now, Ms. Clark, let me ask you one other thing. Can you make an offer of proof to the court that you will have witnesses, as to Ms. Gertsch's, who will testify to inconsistent statements, such as telling other persons that she was truly not there, that she was not in fact looking for a condo or apartment in that area? Any other specifics regarding credibility, specifically as it comes to this case?
Yes.
Tell me about that. You can make that representation
Yes.
that you will have those witnesses?
Yes.
All right, any further comment, Ms. Clark?
With respect to Rosa Lopez, I can only indicate, Your Honor, that we were unfortunately sandbagged badly in that respect as well. Upon reading the transcript, I was stunned to realize that counsel attributed many statements to her that allegedly were made to Detective Furman on the morning following the murders, when in fact his own statement indicates that all she said to Detective Furman was she heard noises. It took an extensive and exhaustive review of the transcript to realize, to go back to find exactly what those statements were. And counsel then reiterated it again today to this jury, which compounded the harm in his failure to turn over that report, which we still don't have.
Right.
We still have no statement indicating that.
Mr. Cochran, is there no report about that?
Absolutely none, Your Honor, if I might respond.
Then how do we know that then?
because we went and talked to the witness, we talked to her, they had the report, when we got the report, Your Honor, they had this is a key witness, obviously. They know that she talked to Furman that morning. Don't they have an obligation, do we have to do their job also, Judge? Don't they have an obligation to talk to Rosa Lopez like I did? There's no further report. That's the thing that's so amazing about what they're saying. We don't have to do their investigation, Judge. We're the defense in this case. We don't have to do their investigation. This is unprecedented. We have them whining and moaning. This is just opening statements. We haven't even started the trial, Judge. And all this emotional, vitriolic, everything is misled, and everything they do is perfect, everything we do is wrong, and we are just doing our job, Judge. And it's absolutely incredible that she sees all these exhibits and all these things and wants to rehash everything with you, Your Honor. We offered that these things should be over at some point. We ruled on the other things. Yet we have to relitigate everything over and over and over again, Your Honor. And I don't think that's fair. It's not fair to Mr. Simpson.
You know, Your Honor, I'm appalled. You know, what, does counsel think it's his job to mislead and to sandbag and to ignore the law and to flaunt the law?
All right, counsel, I'm just
Okay.
asking for, I just asked Mr. Cochran for an explanation. Is there a statement of Rosa Lopez that contains attributes to her the comments that Mr. Cochran made today and the day
Right.
before?
This
That
is
was
their
my
witness.
question.
Yeah, this is their witness. And when they take a further statement from a witness, they're obligated to turn that statement over, and as we always have. There have been multiple statements for some witnesses in our case, and the prosecution has never been derelict in its duty, has always fulfilled that duty to
All right.
turn all of them
Well,
over.
Ms. Clark, here's the problem. There's been a representation made to me that no such witness statement was taken. All right?
Nevertheless, obviously, the statements were made, weren't they? And we were given no notice of the fact that the witness made further statements that are of a much different nature.
When that witness is called, you may make a new objection, and I will contemplate precluding that witness from testifying, based upon the fact that it appears that at the time of opening statement, there was a clear intent to do that no statement was in existence, that additional statement was not disclosed. I've already made finding as to other witnesses that this failure to disclose was intentional and deliberate. You can renew your motion then, but at this point, I'm not going to entertain any further sanction as to Rosa Lopez.
We would not ask the court to preclude her testimony, Your Honor. We would ask an admonition be given concerning her testimony.
All right. All right, court will rule as follows. The prosecution will be allowed to briefly reopen its opening statement. It will be allowed to go into inconsistent statements, specifically with regard to this case, regarding Mary Ann Gerchis. Prosecution, because the defense did not disclose the identity and nature of expert witnesses who would be testifying regarding arthritic condition, may merely say that now that we know that this is going to be an issue, we're going to show you this videotape or these outtakes. Prosecution may mention the fact that Howard Weitzman was having not been disclosed, that the information that you have, the evidence you will present, will be that that was not in fact what happened, that Mr. Weitzman was in fact allowed, or however you feel the evidence will come out as to that. As to the allegations of misleading the jury regarding the EAP blood types, I'm going to defer ruling on that until I've seen the laser disc. I'm going to sustain the court's own objection under 352, undue use of the court's time as to the circle of benevolence argument and the Taft prenuptial agreement, because I don't think there's any that's a matter of interpretation that can be done through the evidence and not through presentation of the argument through opening statements. All right, and Ms. Clark, I'm going to give you a 10-minute time limit on that.
Very well, Your Honor, so, but we're going to need... I would like for the court to, I would like to await the presentation of the opening statement until we know the court's decision on the blood issue.
That's a much different issue. That doesn't go to sandbagging at discovery. That goes to the show and tell issue. That's a different issue.
But the resolution of it is the same, really.
Not really.
What other resolution could there be?
Well, that's a completely different issue that I'm not going to entertain until I see the laser disc. All right? But we have an hour left of court time. There are other sanctions that I can impose besides that, but I'm not convinced that a sanction is appropriate in that case.
With respect to that Laserdisc?
That's correct. I want to see the exhibit itself. If the exhibit, this is my thought on that. If the exhibit, although highlights one section, if the rest of the sentence is visible and there's a complete sentence available, that was exhibited for a long period of time in great detail to the jury. It may not have been misleading in that context. And Ms. Clark, please don't misunderstand me. I realize the pressures that you're under, both professionally and otherwise, and I really appreciate them. But at some point in time, when we have our show and tell and we make rulings and we agree not to, or we waive objection to things, that should be the end of it.
I appreciate that, Your Honor. I think that,
I agree with you, that's an important part. I agree with you, that's an important issue. But I need to see it before I can rule on it. I've given you something that's virtually unprecedented in any criminal case I've ever seen, the opportunity to reopen, but it's a sanction I think that's available to me within the spirit of 115. But those are the only 3 items that I'll allow you to reopen on. And you have a 10-minute time limit. All right, now, after we finish that, then what are you going to present? I understand there's a tape recording I need to listen to.
yes.
What is that? Tape recording of what?
Let me defer.
Mr. Darden?
Your Honor, 2 matters. We have not seen any video outtakes. We'd like to see them before the jury does. And I respectfully suggest, Your Honor, that you might wish to repeat the exhortations the counsel made on the opening day. I do not believe that personally directed epithets add any grace whatsoever to this proceeding.
I was actually, Mr. Bailey, I think I've spent a lot of time jumping on them today. So I was waiting for one of you to do that so I could jump on you to make the point, so. All right. I have to balance my excoriations from time to time.
You wanted some information?
Yes, Mr. Darden, what I'd like to know from you is you indicated to me at sidebar off the record that you were going to present apparently the audio tape of the 1989 or 1985 9/11 call.
Yeah, the 911 call from 1989. Yes.
1989.
Yes.
All right. And also you indicated that in the course of the reopened opening statement that you were going to present outtakes from an exercise video. Is that correct?
That's correct.
When did you receive those outtakes?
When did we receive the outtake? We received the outtake some days ago, and we pressed them onto a laser disc yesterday.
All right. Well, let's see what they are. Let's see what they are.
Also, there's a cut version of the Roy Firestone interview, which they have not seen,
It's called edited.
edited.
Anything else, Ron?
I advised Mr. Cochran of the Firestone interview editing earlier.
Mr. Bailey, you had a comment?
Yes, Your Honor. Mr. Cochran has suggested to me, and I endorse the notion, that in fairness to this witness who's been battered all over the courtroom for merely having the unpleasant experience of being a witness, that we might have a hearing on these alleged impeaching witnesses to see if they exist and what they really say before the jury is given that tape, which we can't undo for 3 months. Could they be brought in and appear before Your Honor just long enough to assure us that they exist and they have such testimony to give? Pretty good job has been done on Mary Ann Gersha so far. We're going to find our witnesses going to other countries pretty soon.
I'll think about that. But at this point, let me see these other items. Do we have the laser disc of the,
Yes, Your Honor, this is a full cube tape of the 10-minute segments of outtakes.
Before we play that, can we approach without the reporter for a moment?
sure. Counsel. All right, I've been advised that the outtake material is still copyrighted material. So it's released to the outside video feed will be interrupted for the playing of this item.
As I understand it, Your Honor, it will last approximately 10 minutes.
All right, counsel, it's 10 minutes after 4 right now. I still need to hear the audio tape, still need to hear argument, et cetera, on that. I don't think we're going to finish with the jury today. My inclination is to send them home at this point.
As far as the audio tape is concerned, it's the same audio tape that I assume the court listened to back when we did the motion to eliminate regarding the DV.
Yeah, but by the time I finish watching 10 minutes of video outtakes, and if there's some objection to specifics, by the time we finish that argument, it'll be 4:30. You're ahead of the game right now, Mr. Durden, anyway. Deputy McNair, why don't you call up and let the jury loose for this afternoon? Thank you. All right, let's see the outtakes. All right, let's see that.
Actually, for that, I will need to change.
What's the copyright status of this material?
You know, I'm not sure at this point in time.
Yeah. Ready? Sure.
On 3 occasions in the last 8 years, O.J. Simpson appeared on this program with me. A segment that originally aired in 1989. I asked Simpson about his pleading no contest to a charge of an assault on his wife, Nicole.
The day after this was over, we looked at each other. We had a fight. We were both guilty. No one was hurt. It was no big deal, and we got on with our life. As a matter of fact, after the Rose Bowl, we hosted a party for a great deal of amount of people, and mostly our friends. Took a trip with a couple of friends who never even knew we had an argument that night, and then 30 days later, I'm reading in the paper, this major thing had happened, quoting things that people say to one another in the middle of an argument, right and wrong. I mean, it wasn't all right what you read in the paper, But it was embarrassing, but because our relationship was strong and all our friends knew it, and they knew what they were reading wasn't necessarily the truth, hey, we just tried to put it behind us and ignore it as much as we could. I mean, we could have easily gone to court and been on the stand, and I think even the city attorney's office realized that they couldn't have won it, but that wasn't the point of filing. The point was to bring attention to a new law that's on the book, and who better do that than me? And I just said, why me? Why am I the guy that you choose to do this? I don't think I'm a good example, and I don't think this incident this night was a good example of what you guys are trying to, bring to light.
That is the end of this particular segment.
All right. How long is the audio tape? I'm sorry?
I'm removing the tape from a exhibit that has already been sent to court. It is tape labeled T55.
testify, and she will authenticate. Okay.
I have a moment, Your Honor. I'm not quite familiar with this new tape deck and the press sources.
Well, he's searching for the goods, Your Honor. What is this remedial to? Obviously, Mr. Darden could have played it in his opening, decided not to.
No, this is you objected, lodged some objection to this. This is part of our 402 hearing as to the tape.
Okay, this has nothing to do with reopening.
No, but I figured since we're here, we sent the jury home, we got all the equipment, we might as well listen to it all at one time.
Yes. He's going to listen to us at some point about the video and everything.
Is the Firestone tape also something coming into evidence, not for reopening?
Yes,
Okay.
correct. The only thing that we watched for the purpose of the reopening was the workout tape.
Fine. And as to that, I assume that if you permit them to describe it and show it reopening, it will be on a commitment that it will be introduced in a case in chief, and that it's admissible for all purposes and not some limited purpose.
I assume so.
All right.
Yes. Yes, they were.
Misplaced plug.
Proceed. A little more volume on that.
You calling from 360 North Rockingham, apartment number B? Okay, please hold on.
So from Wilshire, Normandy at the highest. Suspect one is a male black, 5'10", 150 to 160, 25 years of age, wearing blue jeans, dark colored top. Suspect number 2 is a male black, 5'7" to 5'8", 150, also 25 years of age. Continuing wearing on dark clothing. Weapon used was .30 revolver. The vehicle suspect went in was it's going to be an 84 Buick blue. It's going to be one John.
Okay, let me give you this part. Wearing a gray sweater is shooting contact.
5514 Service Avenue, apartment 102. 5514 Service Avenue, apartment 112. Mills from River Albany, loaded in code 2 items, proceed to 677. 7L40, I'll need BTA for my tow request.
Normandy at the Hyatt. Suspect described as a male, black, 5'10", 150 to 160, 25 years, wearing blue jean and a dark colored collar. Number 2 is a male, black, 5'7", 5'8", 150, 25 years, wearing dark clothing. Weapon used is a .38 revolver. 911 emergency operator 74 Buick. License 1 John Adam Henry 129, 1 John Adam Henry 129, last seen westbound Wilshire. Property taken with $16.
7L40, disregard.
West LA and Anthony available West LA and screaming woman 360 North Rockingham Avenue, 360 North Rockingham Avenue, apartment number B. Female we heard screaming over the phone in West LA and close to high incident 1376 9813.
I don't know, sir. No, ma'am. Why? What's the problem?
We apparently turned the volume up during the middle of the screens initially. As I said, the dispatcher would be here to authenticate the tape.
Yeah, I couldn't tell what was the part they're trying to play. It's not clear.
You wanted to hear the tape.
Can we go back to what he's trying to actually tell the jury? It's not clear, God, what we heard all together.
All right, well-
The whole thing?
Yeah.
You think that?
That was the whole thing.
There's actually, no, there is more. It relates to other calls.
In his opening statement, he said we were going to hear slaps.
You will.
And, who's going to identify and authenticate that? Who do they have that was there can identify and authenticate slaps?
The dispatcher. And if you listen to the tape, you can hear it too. And as I said, I think we turned the volume up during the middle of the screens.
Your Honor.
All right, well then, let me hear it from the top then, because that's all at the beginning of the tape.
So I would like to hear that again. Because
I'd
how
like
can
to-
the dispatcher tell us there's slaps? She can't do that.
Well, that's why we're having a 402 hearing, Mr. Packard.
That's why we have a jury.
Yes,
Let
Your
the
Honor,
jury.
But no, but the point I'm trying to make. and I'm
Oh, I understand the
getting
point,
is
counsel.
that
Well, let's
we're-
listen, let's listen to the tape.
Yes. okay.
Some things are,
Did you hear the screaming though?
I didn't stand up and whine and moan when you made that statement, Your Honor.
Oh, I'm not
Something
well,
whining and
now
moaning,
you're
Mr.
giving me the
Coughlin.
opportunity. Gentlemen, really, this is getting out of control, and ladies, this is getting out of control going back and forth. You can make the same points, you don't have to engage in the personal invective. There's only one thing that really irritates me. I'm very patient, I let you guys talk a lot, but the thing that irritates me is the personal invective. All right, let's hear it from the top. I'm sorry? Okay.
Hello? You calling from 360 North Rockingham, apartment number B?
Let me ask you this, Mr. Darden, what generation tape is this? Is this a first generation off the large 24-hour reel-to-reel that LAPD has?
It's a second generation tape, I believe, off the reel to reel.
All right,
Shall I proceed?
please.
Emergency operator 461. Hello? You calling from 360 North Rockingham, apartment number B?
All right, thank you. I'm sorry? No, let me see everything that we got. Let's do all the show and tell, and then we'll take them one at a time. All right? Mr. Harris, so good of you to come back.
I should indicate that, we will, working with the controls, we'll filter out some of the noise, and you will hear, as the dispatcher heard just last week, as did other dispatchers here, as did I here, and as did other people in my office. You'll be able to hear them.
Counsel, we'll get to that. What I'm indicating, I want to see all the exhibits first. No, Mr. Harris is now here with our the famous laser disc. Let me know if you're going to bring up the victim's body again. I hope the delay person caught that. All right, let me see the original, the full. Do you have the full report without the emphasized portion, Mr. Harris? No. Okay. All right, counsel, just so we understand the parameters of what we're talking about here, as far as the question for reopening of opening statements by the prosecution, the issue was the court wanted to see the workout tape, so-called outtakes, that the prosecution wishes to present because the testimony regarding expert witnesses regarding the defendant's arthritic condition were not disclosed to them prior to the opening statements. Then also the prosecution wanted leave of the court to complete the pictures, quote unquote, as far as the EAP blood type. And I reviewed the exhibit just now. So let's settle the issue of reopening opening statements, and then I'll hear the 402 objections to the evidence. Ms. Clark, workout tape and the EAP item. Right. Do you have anything else you want to say in support of the tape?
In support of the workout tape, Your Honor?
Yes.
Only, I think I've...
All right. Mr. Cochran, those two items, laser disc and the workout tape.
Thank you, Your Honor. And I'll be very brief, Your Honor. With regard to the workout tape, I mean, we all saw the workout tape, and I think that I'll submit it, except to say that there was some moment of levity about giving your wife room or something like that. I don't know how that's relevant to anything at all. The latter part where Mr. Simpson is talking to the trainer apparently, and he's saying you have to give your wife room or something like that, or some statement when they're moving their arms. I don't know if the court noted that. I don't think that's relevant, and I think that could be ambiguous and misconstrued. my only, or you can turn the audio off at that point if you want to just show that. If the point is to show what he can do, why would you need the audio at that point? In addition to that, I still fail to understand what we said that would allow them to do this in a reopening, which is, the court has already said is so unusual. Because let me add this one thing.
Sure.
As I indicated to the court before, one of the advantages, and I think this seems to get lost so very often here, that who would know better than O.J. Simpson that he has rheumatoid arthritis, in addition to the fact that we do have doctors who are treating him. But I'm saying that we would know that, and so I don't know how they're prejudiced, and I don't know how this tape helps with the rheumatoid arthritis. He talks about his knees, he talks about those things. So I just wanted to point that out. I think that if you do think that it's relevant and should be done, it seems to me that I think we're stretching it, number one, but secondly, any conversation with regard to your wife or giving your wife room or whatever that statement was, you may want to look at that again. I think that would be improper, ambiguous, and would not be appropriate to be shown to the jury. The other aspect you asked me to address was with regard to the EAP blood. As the court can see, in the show and tell, it's locked into the laser disc. We put the whole exhibit up, took out the portion the court could see what we took out. That was shown to Ms. Clark. It was shown to everybody. This idea that they were rushing, well, that's not true at all. They were shown this, they looked at it, and with everything else, they continued to object. Even, to give you an example, Your Honor, this morning, Ms. Clark has this selective memory. She'd forgotten about the Furman thing. Out of abundance of precaution, I went back and told her again, Furman, she didn't recall that. You'll recall she argued about Van Adder, said we couldn't do that, and you'd already ruled on that. She will re-argue everything, and I think that's the point with his EAPB. We made that very clear, and it is absolutely outrageous for them to talk about misleading. We don't have to accept the fact that whenever anything points away from their theory of guilt towards innocence, and they want to talk about it being degraded, Your Honor, there'll be a lot of evidence about possible degrading. But that, again, that's their qualifier. That's their speculation. We don't have to accept that. We took the point that was made at that point, if the court pleases. And I think it's very abundantly clear.
All right.
First of all, with respect to the videotape, I think the statement that is made by Mr. Simpson is relevant and should be allowed to remain in.
Well, that goes to a different issue. You know, whether or not it's relevant to issues of domestic violence and flippant comments made about, spousal abuse, that's a different issue. You want to use it to reopen regarding arthritis. That's what you've asked for, not domestic violence. First segment deals with a workout. Second segment contains, I think, the comment, if I'm not mistaken.
Was it?
Since this is the first time I've seen it. All right, if the issue is the arthritis, at this time, I'm inclined to allow you to use the first segment only
For the presentation.
for the presentation. Now, when
Why
we
don't we
get,
just take the sound out? Since the issue is the arthritis for the opening. Wouldn't that resolve it?
all right,
No, we don't want, no.
sure.
Absolutely not. Well, he wants the sound out because he says, I've got these bad knees, you can't use these knees. I mean, what is this? I think that would be totally unfair.
First segment.
That's right. This is our case in chief, Your Honor. The council can put in whatever they want to put in when it's their turn.
Ms. Clark, here's the problem. Second segment clearly has problems with that statement. I'm not saying it's not coming in, but that's not the purpose you need it for the opening statement. All right? So you're asking for too much to get that in at this point. The first segment shows Mr. Simpson doing various exercises, stretching. He mentions the knees. That's what you need. That's what you want for your opening statement. That's what you can have.
Is the court requiring us to use sound?
That's what it is. You want a videotape, you take it the way it is.
Your Honor, if we don't want to use the sound, it's easy to take out. We can simply show
But
it.
then
That's how I saw it.
But then it's a misrepresentation of what's there, isn't it?
I'm sorry?
Then it's a misrepresentation as to what it is.
Kind of like what counsel did, you mean?
Do you want to use it or not? Yes or no? Use the videotape, don't use the videotape. It's up to you. First segment, that's all I'm going to allow in because that's all it's worth. All it goes to is the arthritic condition. Sure. Okay. Second thing is the EAP, the thing on the laser disc. I've seen it now. Any other comment?
I think the court can see how misleading it is. And I only wanted to indicate to the court that the defense violated the court order regarding the show and tell, showing up late with it on Monday. I do not recall having seen it. but we were hit with so much at the last minute. And as a result of the defense violation of the court's order as to when those exhibits were supposed to be shown to us, we were pressed into examining a huge number of exhibits, all at the last minute, with about seconds for each one. The result of a defense violation of a court order should not be that the people are under the gun and held their feet to the fire. That should not be the result. The people should be entitled to examine things in a more leisurely fashion. And the defense is simply pushing the court and pushing the court in order to get the court to push the prosecution unfairly in order to gain more tactical advantage, which is what they did exactly with the exhibits as well. It's a very consistent pattern here. We have a constant effort to sandbag and take the prosecution by surprise and try to make this a trial by ambush. They don't want the truth to come out. They want to put a stranglehold on us so that we cannot meet their evidence and meet their representations. And that's why everything is being hidden and popped out at the last minute. Too many last-minute surprises. And nobody's perfect, Your Honor. If we made a mistake, then I apologize to the court. That's what happens when people do things in a hurry. Mistakes get made.
Thank you, Ms. Clark. All right, the court's ruling, I'm sorry.
The court, this was argued on the 23rd. The court didn't even rule on this till the 24th, I think you'll find the record.
All right, counsel, the court's ruling stands as to the prosecution motion to reopen. They will be allowed to reopen as to Ms. Gerchis. As to the inconsistent statements, they will be allowed to reopen to show the first segment of the workout videotape. They will be allowed to reopen as to Mr. Weitzman, since Mr. Weitzman was neither on the witness list or disclosed prior to the opening statements. I am going to sustain the objection to reopening as to the EAP blood type. All right, let's discuss then in the opening statement, the prosecution's first witnesses and evidence. Certainly. Clarification question?
Question.
Yes.
The question has to do with, the court indicated that he wasn't on the witness list or whatever. I'm indicating to the court he wasn't on the witness list, but for the prosecution to make this statement, I'm representing this court that Mr. Weitzman is going to say, along with Mr. Tapp, that he was asked to leave and was not allowed in that room.
And I assume that they're going to say that defense counsel made this representation to you. We're going to present witnesses who are going to tell you that that's not true. This is what our evidence is going to show, and that's all they're going to be able to say.
Okay, I just want to make sure, because Weitzman's going to, for a lot of us, he's going to be coming in along with Skip Taft and others who are going to say what actually happened.
I suspect so.
Thank you. Just want to make sure that it's clear.
All right. No, it's crystal clear.
Okay, thank you.
All right. As to the Roy Firestone tape, any comment, Mr. Cochran?
We're now to the trial evidence, Your Honor.
That is correct. Two issues we're talking about here are the 9/11 tape and the Roy Firestone tape.
Well, let me then take, you asked me about Roy Firestone first. Let me take Roy Firestone first. It's a television interview, Your Honor, and I'm not clear for what purpose this is offered. It seems to me that if they're going to call Roy Firestone, I'm not sure they're calling Roy Firestone or they're just going to play the tape. Seems to me they'd have to call Roy Firestone as opposed to just playing the tape. Is there going to be a combination thereof? May I ask that question first? It has some relevance. You're just going to play a tape, and is that all that's going to happen?
I don't know. Mr. Darden?
Well, I think the tape is self-authenticating. I don't think I have to call Roy Firestone. It speaks for itself. Either that's O.J. Simpson or it's an imposter.
Well, the problem is, how do we cross-examine the tape? That tape is cut after an interview. When you go, if the court's aware, when you do an interview, well, I shouldn't use that as an example, should I? Forgive me, Your Honor. When one does an interview, sometimes they last like 5 days or whatever. You know, let me tell you, Judge, they cut these interviews.
Oh, Mr. Cochran, you really know how to hurt a guy.
No, Your Honor, no. What the point I was trying to make, Your Honor, was that this interview is cut in a particular fashion to be shown over, let's say, a 22-minute period of time if he has a half-hour show. We can't cross-examine that. I'm sure that Mr. Simpson, as he sees that interview, will say, wait a minute, they cut this other part out that I said. If we have Roy Firestone, because otherwise it becomes hearsay, a form of hearsay. If we have Roy Firestone, I can ask him, well, didn't Mr. Simpson say so-and-so in addition to that? So we don't have that. So that's my first objection to this. I mean, I think that, again, as much what they do, it seems like it's much ado about nothing, but it seems that here's an interview in '89 where they're going to show the tape without Roy Firestone. And, Judge, I just think we'd be entitled to have Mr. Firestone as part of their case, because I think otherwise it's hearsay. I cannot cross-examine or show the circumstances of this particular tape. And I think that's unfair to the defendant. We're deprived of a constitutional right in that regard.
All right, what are your comments on the 9/11 tape?
The 9/11 tape, Your Honor, I was a little surprised to hear Mr. Darden say he's going to clean that up. Now, here we are.
I didn't say that.
I thought he said he was going to cut something out of it or
I
do
didn't
something
say
out of
that
it.
either.
He said something about doing, don't talk to me. Your Honor, I'm talking only to the court. I thought that Mr. Darden said something about cleaning something up or whatever. We don't want that tape altered. And I'm telling you, Your Honor, and I'm sure you've heard a lot of tapes in your life, and for him to have gotten up and said those were slaps, I think that that's going to be a major problem for him. I don't think that any dispatcher can talk about these being slaps. I think we have a further hearing regarding that person's qualifications. Based upon the tape that we've heard, I would ask the court whether or not this court is prepared to allow anybody to testify those are slaps. Certainly didn't sound that way to me.
All right, do you have any problem with the screaming woman in the background?
Well, I don't, no. I mean, if there's somebody who's screaming, if it's identified with this case, you say I have a problem with it. I'd rather not have that, of course, but I mean, I don't have a problem with it from a standpoint of their order of proof, if that's what they're trying to do. But he got up and told the jury they were going to prove slaps. I don't hear that. Then he tells us today the dispatcher can hear it, he can hear it, and he's going to do something with it to make it clear. And I don't think that's true at all. That's why we have these 4-3 hearings. So I do object based upon that, Your Honor. Until it's something that's relevant, it's something that's not speculative, and Your Honor, I want you to note that I'm not asking to reopen my opening statement so I can say that, gee, he misled this jury. Sometime or other we got to try this case, don't we?
Well, I hope so. Mr. Darden, let me ask you this. As to the Roy Firestone tape, I seem to recall that I sustained objections to the defense using a montage of videotapes, which I could tell were the crime scene at Bundy. I recognize the persons who were there, but we don't know where, when, how, and whether or not they're outtakes. And there's a foundational problem with it that the prosecution advanced, and I sustained that objection in your behalf. Mr. Cochran raises the same objection to the Firestone videotape. It is apparent who's there. It's Mr. Simpson, it's Mr. Firestone, and they're talking about the '89 incident. But there is still an authentication foundation that has to be laid. It is not inherently self-authenticating.
I think that it is, Your Honor. In discovery and during the DV hearing, I provided the court and counsel with a complete copy of the program, okay, and that is a portion of that program. And so whatever concern Mr. Cochran may have in regarding the authentication of that particular tape, there's no issue there. And you can't cross-examine a videotape. That's absolutely correct.
Well, here's the problem,
But he can't
Mr.
put
Darden.
on a defense.
There's an objection. There's a foundational objection is what I'm hearing from
What
Mr. Cochran.
is the objection? He has a complete program, and I want to play a portion of it. I have no duty to play the entire program, especially given the fact that it's not relevant to these proceedings. And so I want to play 4 minutes of that program that relates directly to an incident which the court has agreed is relevant and admissible in this case.
All right. Well, Mr. Darden, let's assume that I don't buy the argument that it's self-authenticating. Where does that leave us?
You're the judge. That's where it leaves us. I say it is. I say the evidence code would likely agree with me. I mean, it's a portion of a complete TV program which the court has seen, and which Mr. Cochran has seen.
I have the evidence code before me. You want to cite me to a code section that says that videotapes are self-authenticating?
No, I don't.
Well,
No,
yeah,
I don't.
I mean, you put me
No,
in
I don't. But it's like any other writing. Okay, videotapes, like writings, can be self-authenticating. Okay, you have the date of the interview right there. We recognize the people in the videotape. They're identified in the videotape. Okay, we know the date that it was aired. We know it's an ESPN video.
Well, I agree with you. I know all these things. The problem is that they're objecting.
I'm helping them out. I'm trying to show them where they're wrong.
Okay.
Look at the videotape, the content of it. You want to know who produced it? You want to know the date of the interview? You want to know the subject matter? You want to know the name of the interviewer and the interviewee? It's all right there. What can be more authenticating than that? It's right there in front of us.
Well, isn't what's in there, the date on it, hearsay until somebody authenticates it?
No. Would it be in a letter? Couldn't the letter be self-authenticated?
Depends on what
does
the letter
someone have
is.
to come in and authenticate the date? I mean, the letter speaks for itself, just like the videotape speaks for itself.
But we just can't bring in letters. Somebody still has to testify who wrote it, whose handwriting it is.
Except that in this case, you don't need that because you see the faces of the persons who are speaking. You see the face of the person who is asking the questions. I mean, if you want someone from ESPN in here, fine, okay? I mean, that's fine. That's no problem.
No,
I'll get
it's
someone
not
from
me
ESPN.
who wants it. They're raising the
okay.
objection. I just as soon leave the ESPN people at home.
Sure, I'll get a clerk to come in and say, this is a program that aired at ESPN. This is a TV program. This is our videotape. It's a true copy. And that's that. And that's all that's required under the law.
All right, and what's your response to the screaming woman aspect, the slapping aspect of the screaming woman tape?
Well, I think that lay people can give their opinions. I'm not going to cut the tape or alter the tape so that you can hear slaps. I'm simply going to adjust the dials on the tape recorder here. If there are no slaps, the jury will figure that out. But let me add this. You have the tape of the screaming woman. You have the operator saying that the call originates from 360 North Rockingham, and you have her dispatching police cars to that location. You have officers arriving moments later. You have Nicole Brown Simpson, who has evidence, physical proof of having been slapped, plus you have her spontaneous statements. Okay. I think that when you look at the totality of the circumstances, I think, A, you're going to hear slaps as we adjust the knobs on the tape. But then again, there's also physical proof that the defendant slapped her, and he admitted it later on. I mean, he admitted harming her in his letters to her. So, what's the issue? What's the problem, Mr. Cochran?
All right, briefly.
Some of the problem is the evidence code is pretty California. That's the problem. And hearsay and other things like that. I mean, it's not productive to tell you that you're going to hear slaps. He's told the jury that already. We've all heard this tape, and you're not going to hear slaps. It's a matter of interpretation. What I think we should make very clear, Your Honor, that counsel needs to read the evidence code with regard to that videotape and regarding, because there's analysis of that in the letter. That is not foundational, and I think we still have a problem. And I don't think you can just bring a clerk in here who is with an objective, brings a clerk in here to try to lay some foundation for this particular tape. As you correctly pointed out, Judge, when we were seeking to show a tape which everybody had seen at the scene, the court kept that out on various grounds, but it was a montage. These things are cut, pasted, put together, and it's a real problem if we don't have the person who did the cut and pasting. If we're talking about the truth and getting the facts out to the jurors, in which they claim they want to do. So I would reserve further objection. And I was reminded when I returned to my seat that what counsel had indicated was they were going to filter or something, use the words filter, with regard to this noise. We're entitled to have that tape just the way it is, not enhanced, and not just fiddling with the knobs, but the way we heard it here, not so they can bring up something to try to prove something. Further, there's a foundational problem with that tape. The address I think I heard was 360 Rockingham, apartment B. And there's no apartments at that location. There are no apartments at 360 Rockingham. I don't know, I'm not clear about what's happening with regard to that. But I think that there are some further foundational things, and I appreciate the court. That's why we have these hearings. But counsel has not given you asking for a case, asking for a cite with regard to the videotape, and you know the problems inherent with this tape. And this is just, they haven't even called that first witness yet, Judge, and these are the problems they're having with this evidence.
All right, thank you, counsel. Mr. Darden, I think you have I accept your offer of proof that you're going to have the dispatcher come in who was the person who took this call, correct?
Yes.
All right.
She will explain the B. I'm sure not to Mr. Cochran's satisfaction, but I'm sure to everybody else's.
All right.
And she will authenticate the tape. And she'll also indicate that as she listened to the slaps and the beating, that she typed into her keyboard there contemporaneously that fact, the fact that she could hear the woman being beaten.
Is that part of our record of discovery? Has that been turned over to the defense?
Absolutely, Your Honor. Well, he should read his discovery.
I've seen that, Your Honor.
He should read his discovery.
And I'm not seeing it. Furthermore, the fact
Well, he
that
hasn't read it.
hasn't actually-
I'm at the,
Hold it.
I'm,
I'm talking to Mr. Darden right now. Mr. Gargan. All right.
of course, it's part of the discovery, Your Honor.
All right. Mr. Darden, you're accepting your representation that you will have the dispatcher here who will authenticate the tape. I'm going to overrule the objection at this time.
Thank you.
However, the tape appears to me to be overly long because it goes on to other things and other incidents and other. How far into the tape do we get the actual dispatch of the unit?
That process, from the time that you hear the first scream until you hear the dispatcher notifying police
Any West
units.
LA unit,
Yeah.
360 North Rockingham, code
Yeah,
2.
right. It's
High.
it's about 3 minutes. And the problem here is that the dispatcher receives the call, she hears the screaming, and as I understand it, the line is left open. Okay. And so although you may hear other dispatchers coming on and dispatching other units to other locations and other matters, the line is left open and the dispatcher is still listening in.
All right, the
At
tape is
Rockingham.
relevant up until the point where the car is dispatched, but there's a lot of extraneous stuff that's going on there. So what I'm telling you, I'm going to let you play the first part of it up until the point we get to the actual dispatch of the car, because I think that pretty much ends the relevance of the tape.
So you're saying that once the cars are dispatched to Rockingham in the tape?
Right.
Oh, fine.
Question, Your Honor.
Yes.
Is the court allowing the dispatcher to say she heard slaps? I don't think we object to that. I don't think you rule on that yet. How is she able to make that determination?
Let's talk to her when she gets here, out of the presence.
They come forward there, well, I'd ask
Let's
counsel
see.
not to.
And Mr. Darden, why don't you pull up your, the sheet that you have on her notes, and we'll take a look at it tomorrow morning. All right?
Your Honor, when you hear that, who is slapping whom in that tape?
I don't know.
Looks like OJ was slapping. Looks like the defendant was slapping Nicole. I don't know. That may be the point in time when he grabbed her around her neck and left her hand in front. I don't know.
All right, that's enough, counsel. All right, as to the Firestone tape, I'm going to sustain the foundational objection subject to further proof.
Thank you.
Okay, tomorrow morning then, so that we're clear, tomorrow morning at 9 a.m., the prosecution will have 10 minutes to briefly reopen their opening statements, then we will proceed to the presentation of evidence.
Any portion of the
Yes, in addition to the
exercise.
4 minutes of videotape that's relevant. Mr. Bailey? Do you want the reporter? All right, we'll recess 9 o'clock.
Before we do, I just wanted to...
I'm sorry. Ms.
For the
Clark?
record, I wanted to clarify the court's ruling with respect to sustaining the defense objection to addressing the blood. Is the court making a finding that the defense exhibit was not misleading?
No, I'm making a finding that we had 2 days of show and tell, that the prosecution has many lawyers available, at least two, perhaps three, who were assigned to the blood evidence, that the purpose of the show and tell was for counsel to look at these things and to raise any objections. No objection was raised. It's too late at this point in time to ask to reopen as to that issue. That's the reason for the court's ruling.
But how would we have known that he was going
You're
to
just
use...
asking me for the ruling, counsel, not arguing. All right, I'll see counsel at sidebar.